really excited for our two guests today. I have Arjen, who's a Vistage Chair out of the Silicon Valley area here in California, and doing some great things. We're going to hear from Arjen here in a second. And then also we have Harry Barth, who is the founder and senior managing partner of the asset protection, estate planning, and business planning firm Barth Calderon, also located in California. And we're talking about, of course, the Corporate Transparency Act. This is a big deal. Harry's background is a top Vistage speaker, Vistage member, very high demand for his talks across the country. We put on about 40 a year at the law firm. We have about 5,000 clients across the country and have many workshops where we're constantly giving out high value information like this. And so this will be great. And let's just jump into it. A couple things as I get into introducing Arjen here is we will have a Q&A period. So as you start hearing Harry and Arjen get into this, please type in your questions. We're going to address those live towards the end. Harry wants to get through some facts here and updates on what's going on with this law. And so put your Q&A in there. Also, we'll put some other links in there about how to get connected to both Arjen and Harry. We do offer a complimentary assessment on this with Harry and the team. So I'll put a link up in there. If you have questions offline, happy to do that. So all that will happen. And let's get this going. Arjen, obviously you and I have chatted a lot. You're doing some great things there. Tell us a little bit about what's going on with your practice at Vistage.
Yeah, we've got a CEO group that has been meeting for a couple of years, really a great group of people. And we just had a meeting last week in San Carlos that was fantastic. Lots of dynamic conversation there when we went through some of the Marcus Buckingham stuff. So that was fun. We also have a trusted advisor group, really great group of people there as well. So yeah, really enjoying the time spent with Vistage members in my group.
Yeah, and Arjen, you have some opening spots there. Who are you looking for to join your team?
Yeah, we're looking for people with a couple of different perspectives. One, looking for someone with more of a marketing background. Maybe an advertising agency or a marketing agency, a digital marketing agency. Looking for someone who runs a legal practice, a large legal practice. We would love to have a lawyer in the group to bring that worldview into it, and also looking for someone with a strong finance, like maybe someone running an accounting firm or a tax practice or something like that, more with a financial point of view. So we're really trying to create a very diverse group of people who are bringing their perspectives together to create more value for each other.
Right, love it. And we'll put your contact information up in chat. And Harry, let's jump over to you. What the heck do we need to know about the Corporate Transparency Act?
Well, we have a lot to talk about today, and it gets quite comprehensive. So everybody, thanks first of all for having me with you this morning, and I sure hope I can pull back the blinds a little bit and let you have some insight as to what the Corporate Transparency Act is all about. Just definitionally, I think it's important to understand that this is the creation of a national, federal database of the owners, primarily of small businesses. It's for law enforcement purposes, maybe shared with government agencies and perhaps international government agencies as well. And it's kind of critically important. The government's quite serious about it. Failure to comply with this act, $591 a day fine for each entity when we don't comply. And that's for negligence compliance. Then there's a criminal component to it, $10,000 criminal fine and up to 2 years in jail. So ugh. So they're pretty serious about building this up. And it kind of started back at 9/11, and the government's been trying with the Patriot Act, Know Your Client, Sarbanes-Oxley, and other acts to try to build this database because many of the terrorists and money launderers hide behind the shells and of small business entities. So this is targeted for small business entities that many of us haven't owned. Definitionally, I think it's important to understand. I'll be using the term FinCEN quite a bit. FinCEN means the Financial Crimes Enforcement Network. It is the division of the United States Department of Treasury, and it's the division that's been empowered to enforce the Corporate Transparency Act. Now, the Corporate Transparency Act is quite broad. The impact of it, well, first let's start with what it is. Every limited partnership, every limited liability company, every corporation, every limited liability partnership in the United States of America, every single one, unless exempted, is subject to this act. So it could be a company that was formed 50 years ago is subject to this act. So it's very broad sweeping. The numbers that we're looking at, there's anticipated that there are 33 million U.S. businesses that are going to be subject to this act. And as a result of the 33 million businesses, as you'll learn today, we can have close to 200 million transactions. And we have some time limits too. So let's just talk about time limits and then we'll get to some exemptions. So for new entities, which we'll talk about today, that are formed after January 1st, 2024, from the day they're given birth at the Secretary of State's office, because it only applies to entities that are given birth in the Secretary of State's office. So trusts are not included, sole proprietorships are not included, general partnerships are not included. We have 90 days from the time that it's given birth to the time that it must come into compliance or must make its disclosures under the Corporate Transparency Act. For all of the businesses, I mean all of them, that are in existence prior to January 1st, 2024, we have under current law until the end of this year, December 31st, 2024, to bring them into disclosure and compliance. Now, we need to be aware of, before I start getting into the meat of it, some things that are going on. So in Congress right now, there's an act that modifies the Corporate Transparency Act somewhat, that was passed by the House, not yet passed by the Senate, and not yet signed by the President. And it's primarily around extending some of those deadlines. So although we have 90 days for after a new entity is formed, we only have 30 days for a change of information. So once information is filed with FinCEN, then if there's a change in that information, we only have 30 days. It's really too short a time period. So we're going to, that act, should it be adopted into law, will extend that period for changes to 90 days. And it extends the prior companies from December 31st, 2024, thank God, to December 31st, 2025. So an extra year in order to get that done. But that law has not yet passed. So the other thing that's important about the Corporate Transparency Act, there's a bunch of scuttlebutt that's been running around about whether or not the Corporate Transparency Act is constitutional. Let's kind of deal with that so we have an understanding. So there was a lawsuit brought in federal district court in northern Alabama, which was the National Small Business Association versus Janet Yellen, to have the Corporate Transparency Act declared unconstitutional, amongst many reasons, but primarily the reason in that lawsuit was that Congress did not have the authority to adopt the Corporate Transparency Act. It was beyond the power of Congress to do so. The judge in that case ruled by summary judgment, without even having a trial, that Congress did not have that power. So a lot of people thought at that point that the Corporate Transparency Act is unconstitutional, but it's not. So that only affected, if you were a member of the National Small Business Association, the plaintiff, for the moment, you don't have to comply. For all the rest of us, we do need to comply. It doesn't apply to us. So it's very, very, very narrow. Now, now I've been doing this stuff for 50 years. Not the Corporate Transparency Act, because it's brand new, January 1, 2024. And let me tell you a little bit about my opinion on its constitutionality. So I think that the vast majority of the Corporate Transparency Act will be held constitutional. There may be some small aspects of it that we'll discuss in a little while that may be held unconstitutional, which are easily remedied by Congress, but I think it's here to stay. Why? We already have know your client rules. It's been adopted by most Western economies. In Europe, already has a version of this. The purpose of it is noble. You know, it's going after people with nefarious activities. So I think that I think it's here to stay. And already the opinion of the court in Alabama has been appealed by the United States Department of Justice, and that's going to weave its way through the 11th Circuit Court of Appeals. And our best intelligence, if there is any intelligence on this matter, is that the 11th Circuit Court of Appeals will uphold Congress's authority to enforce this act, maybe with some few exceptions along the way, and we don't expect any other court to overrule that, given that we have there. Okay, and remember, this puppy is targeted towards small business. Why small business? Because it's in small businesses where most of this nefarious activity has taken place. It's in the hair salon, Arjun. This is where it is. It's the hair salon that has two hairstylists, but really the cartel is behind it. That is where it happens. So let's talk about the exceptions to the Corporate Transparency Act. I think it's important. There are 23 exceptions to that. So let's run through them together, because these are the people that do not have to fill out all the stuff that needs to be done. Talking about filling things out, you hear along the way, since there are criminal penalties associated with this, and there's virtually no exceptions to filing, not being a commercial for attorneys, but this really belongs, as you'll see, in the hands of a law firm. It deals with control, deals with power, deals with estates, it deals with trust, it deals with asset protection, deals with estate planning, a lot of things. And I think you'd want to deal under attorney-client privilege. Matter of fact, the American Association of Certified Public Accountants has already told their constituency, the AICPA, to accountants, dealing with this is the unauthorized practice of law, get it to a law firm. So right or wrong, burden, cost, it is what it is. So let's talk about the exceptions. So the first exceptions, if you're a public company, so if you're on the New York Stock Exchange, American Stock Exchange, NASDAQ, you don't need to comply. Why? Because the SEC and FINRA and all the rest have already given you a financial enema. They have taken a picture of all of you. They've taken your fingerprints. They've done your background. They know who the people are who are in charge of these companies. And that's very important as we go through this together to understand in the purpose of the CTA, the goal. And this will answer a lot of questions that may come up in the chat in a little while, is to know who are the human beings behind the name. Maybe Blue Ocean LLC. Who are the human beings? That's the goal. And if it's held by another entity, who are the human beings? So we're always looking for the human beings. So in public companies, they know who the human beings are. Pass. Registered investment advisors are exempt from filing because they're registered by the SEC or by the state. Same thing. A lot of information. We know who the people are. They're fingerprinted. They're background checked. Not worried about them. So they're exempt from the act. Venture capital fund advisors, same thing. You know, they're all registered. Then we have large financial institutions that are highly regulated, like banks, credit unions, registered broker-dealers, and securities dealers. All of them, you know, we got all the information. We know who they are. Fine. And trust companies now. Trusts themselves are not under the CTA because they're not born from the Secretary of State's office. Trust companies are large financial institutions and most of the time and are exempt from the act. But if a trust holds a ownership interest in a disclosing company, then all the aspects of the trust need to be disclosed, and I'll go through that in a little while. Public accounting firms that are registered under Sarbanes-Oxley, same thing. We know who they are. They're preordained. We don't worry about them. Tax-exempt organizations, political organizations, charitable organizations are exempt. Governmental authorities are exempt. And very importantly, subsidiaries of an exempt company are exempt. Now, very understand, there are parent and child subsidiaries and brothers and sisters. So, and I'll come back to that in 1 minute. And then the one that's going to affect most of your constituency, Arjen, is this one, what they call the big company exception. Now, this is an and, not an or. This is an and. So if the company has 20 or more full-time employees, as defined by state law, not 1099ers, not part-timers, full-time employees, they have their headquarters in the United States of America. Doesn't matter whether they're owned by a foreign entity, they have an office in the United States of America, and they have over $5 million worth of gross sales. They're exempt from filing under the Corporate Transparency Act. So that sounds interesting, but let me give you a classic example using myself. So I own the law firm Barth Calderon. We have over 20 employees full-time. Absolutely. We are located in the United States of America. Yes. And we have well over $5 million worth of gross sales. So my entity is exempt from filing under CTA. However, Harry has 12 other LLCs and corporations that Harry owns that own real estate, that, lease to other companies, own equipment, own intellectual property, and other trusts and tools that we've used over the years for asset protection and estate planning. The birds of asset protection estate planning are appropriate entities, appropriate trusts to protect people's assets from the government and from, overly zealous, we'll call it creditors and predators. So those 12 that I have are all subject to CTA, although the main mothership is not. And you'll find many Vistage members will have the company, which is an exempt asset from filing, but then they'll own the real estate and they'll lease it, they'll have the equipment in another company, and all of those companies may be subject to the act. Okay, so given that, we understand those are the exceptions. So if we are in the exceptions, we don't need to file. If we are not in the exceptions, we must, with all those egregious penalties that come along if we don't. And they're dead serious about that. So let's talk a little bit, if we could, about what it means to file, process. I think that's critically important. So what we're going to do is we're going to form a new entity after January 1st, 2024. So we'll deal with new entities first, and we'll call it the AHP LLC. All right. And the three of us are forming an entity. We're going to sell widgets. We have a DBA, widgets are us, another DBA, widgets are them. And we're going forward, and we formed it in, we're going to form it in March, of 2024. So let's take a look what happened. So we have a new entity. We don't have the 20 employees. We're not one of the public companies. We don't have 5 million gross sales. We got 90 days from the date that our company is born. We need to file. The responsible party for the filing is our company. So AHP LLC is the reporting company. So we need to go on to the FinCEN website and register our company. So what do we have to do to register that? Well, we have to give it the full legal name of our company. Okay, AHP LLC. We then also must include all of our DBAs. Widgets are us, widgets are them, must be included. We must tell FinCEN our exact physical address, not the lawyer's office, not the accountant's office, not a UPS suite, not a post office box, our physical address of our company. If it's our home, it's our home. We have to do that. And we must include to them a unique financial number. For us, it's our EIN number. So when we formed our entity, we got an EIN number with the IRS, so we give our EIN number to FinCEN to register our company. If we are a single member tax disregarded LLC, which many of our constituencies might be, then we don't have an EIN number. It is our Social Security number. So our Social Security becomes the unique identifying number for our company. So there's the company, step one. Now, step two, they want to know, because remember the purpose of the act, who are the people behind it? Who are the owners? Any owner that owns over 25%, that's not a minor, is what we call a BOI. It's a beneficial owner of interest. And a beneficial owner of interest now needs to file. So Arjen, you got a third. Harry's got a third. Paul's got a third of our LLC. We're over 25%. We are now filing. The company is now causing us to file as beneficial owners. So what do we have to tell it? We have to tell FinCEN. Well, we got to give them your name, Arjen. All right, we give them your name, full name. We have to give them your home address. All right. Again, no post office boxes, lawyers' offices, or UPS suites. And we must upload a color copy of your driver's license and or your passport. That information must go to FinCEN for each beneficial owner. So we have that. 1, 2, 3. The three of us have to file. So here's a quick tip and a quick suggestion. Something that our law firm, for example, couldn't do for you is if you go to FinCEN to their website, and Paul will put that up in the chat in a little while, and you open up an account with FinCEN. Reason we can't do it, they want to know what high school you went to, what elementary school you went to, what color was your first dog, all those security type questions. And then there's two-factor authentication. So if you open up an account, upload that information, your name, your address, and your identifying documents, they will issue you a number. It's kind of like a social security number. And so now, Arjun, for every company that you're involved with, you would just put down your name and your number, and we don't have to go through disclosing your home address and or your driver's license for every single time. So it's a strong suggestion to get a FinCEN identifying number. I got one. It took about 30 minutes, 40 minutes to get it. A bit of it's a Byzantine website as usual.
I just put it up there. I put the link in the chat.
Super. So we have to file that. So there's our 1/3. But I wish it was that simple. It's not, because it's not clear. When they say beneficial owners of interest, they left out some words. It's also anyone with managerial control of our business. So it's ownership and or control. So let's say you own a third, 33 1/3. I own 33 1/3. Paul owns 33 1/3. And we hire Joe Blow Inc. to manage our LLC. We hired a manager, which we could do in an LLC, and we did. Now, the manager has control of our entity. Of course, we could fire the manager. The manager doesn't even have any ownership, all right? But because they have control of the decisions over our LLC, the manager must file. So that entity and all of its owners need to file. All of its C-suite people need to file. If they're the president, the CEO, the COO, the CFO, all right, if they have enough control or substantial control of the manager of our company, they need to file. And if they have a board of directors and the board of directors can replace the C-suite people, my God, then the board of directors needs to file. So as we can see in our little entity here, if we have the control by another entity, that other entity becomes significant in what needs to be done. Now, before I get to my oil well example, which I think you'll find interesting, let's talk a little bit about one other component of filing that's important. For all new entities born after January 1st, 2024, we also have to do something which is called the company applicant. So, Arjun, you came to my law firm and we decided that, a good LLC is good for your business. All right, form it in Wyoming and authorize it to do business in California. So I gave you that, and then one of my paralegals, Cheyenne, filed the necessary papers with the Secretary of State of Wyoming and the Secretary of State of California. The moment when we did that, we also now have to disclose who was the paralegal who filed the paperwork on behalf of our company. So Cheyenne and her FinCEN number needs to be disclosed. And if I'm the attorney that suggested the LLC to you, the supervising attorney, I need to disclose that so the company applicant is the attorney, and whoever did the actual filing are the company applicants. They need to file as well. Ugh. So let's just take an example of we're going to drill. And we're talking to Vistage Chair in Texas. And a lot of people in Texas, of course, as we all know, they're all in the oil business. All right. So they're gonna drill an oil well in Texas because it's a good thing to do. And be telling me about the structure of the oil well. So an oil well, drilling an oil well is by its very nature, risky business. So they don't drill oil wells as sole proprietors or general partnerships. They form an LLC. It's a Shell number one LLC, and that's going to drill an oil well because there's blowouts, injuries, problems. It's like building a house or starting a business. There's risk associated with it. So they form an LLC, which is appropriate. That LLC is a reporting entity. The owners, usually there's 4 or 5 investors that are in that LLC, and that's how they bring in their investment. Each one brought in $1 million. They got $5 million to drill the oil well. Each one of those investors typically is an LLC. So you got 4 or 5 LLCs owning the LLC. So all of the disclosures of the owners of the 5 need to be disclosed. Typically, Arjun, those are held by holding companies. So the holding companies need to disclose. And then for good old estate planning purposes, you wouldn't have it in your own name or it all wind up in probate. God forbid we die. It's usually held in a trust. Some trusts are asset protection trusts. Some trusts are irrevocable trusts. But typically, your ownership interest is held in a family trust, a typical family trust. But if the family trust, which is not a reporting entity, owns 25% or more of a reporting entity, guess what? It becomes a reporting entity. So now do we have to report in the trust? Well, we got to report who the trustees are. We have to report who the settlers are, who created the trust, because they can have transactions with it. We have to report who the trust protectors are. If there's something which is called the general power of appointment, which can direct the flow of assets within a trust, there are a number of very specified positions in trusts that we all name for asset protection and estate planning purposes. All of them, including the beneficiaries, now need to be disclosed. So from this one oil well, for an example, you can have 50 disclosures that are associated to be in compliance with the Corporate Transparency Act. At least it's good to know that for all of our pre-existing entities that exist prior to January 1st, 2024, we don't have to put down the company applicant. We don't need to figure out who is the attorney and who is the paralegal or who filed LegalZoom, who filed those documents. It's only for new entities moving forward from January 2024, because the attorney that put together their entity, their S corporation, 5 years ago, or 10 years ago, or 15 years ago, may not even be known, whatever it may be. So, as you can see, there is a significant amount of reporting that's involved to be in compliance with the Corporate Transparency Act if we have an entity that needs to be registered under the Act. So there are some things that maybe are not quite as obvious. So all of our pre-existing entities, even our new entities that are being formed. So, if we form an LLC, you need an operating agreement. If you form a limited partnership, you need a partnership agreement. If you form a corporation, you usually have a shareholders agreement and bylaws. Now, going back, I think it's mandated that all of those documents in the past need to be amended, and all new documents moving forward need to have language regarding the Corporate Transparency Act. Since the company is responsible for reporting, all right, we need to say that if you are going to be a member of AHP LLC, you will comply with the Corporate Transparency Act, or we will not allow you to be a member of our entity, because you're going to bring fines and penalties upon our company. There are no exceptions. One of the areas I think that might have some constitutional questions is right there. So if we turn around, Arjun and Harry, we make our disclosures, and Paul's saying, no, I'm not doing it. I'm not doing it. But AHP is required to do it, and Paul's not doing it. We're not in compliance, and there are no exceptions. So if the end of 90 days comes, the fines start building up, $591 a day. So we got to throw Paul out. We can't have him as an owner. Well, we got to buy him out. We got to do something, because if they don't know who the human beings are, FinCEN is not allowed to accept the filing. So, and you're looking at a new entity that's formed, a tad easier, Arjun, because we know we formed it. We know who the people are. We know it's going to be in your trust. We know it's going to be, maybe held in an LLC that's held in your trust. We can figure it out. But the legal structures are in the estate plan that's held in your trust. Who has authority to move things is really a legal determination, and a determination that could only really be made by an organization that understands wills and trusts. Control, substantial control. It's a legal determination. Is that CFO have enough control or not enough control? Should we make sure that CFO is registered? What if that CFO, and then what happens when the CFO moves, since the pandemic, moves to another state, gets a new driver's license, changes address? Company better have a procedure or knowing to make sure that they update their information with FinCEN so we don't run out of compliance. So there's a lot that needs to be done, and we need to know all these various different components. For pre-existing entities, prior to January 1st, 2024, think about it. They may have been divorces. They may have been minors that had trusts that are now reached the age of majority. There may have been deceased owners, and that shareholder agreement, operating agreement, partnership agreement hasn't been revised or changed. All right, it's been in the trust. The trust has been amended 6 times. We're still driving down to, at the end of the day, if we don't know who the human beings are who are currently in control, done. What if you have a minor? Minors don't have to report, but they reach age 18, they must report. But the parents need to report on behalf of the minor. But what if the parents are divorced and they're not talking to each other? Or we have an estranged owner that owns a percentage of our company. This is very, very challenging, very, very difficult. And FinCEN has been ordered not to accept a filing unless it's complete.
Harry, how do you define control? Arian's asking, is it arbitrary to an extent?
Kind
How
of.
does the act, how is it defined in the act?
They just call it substantial control. Any
That's
individual or entity that has substantial control over the major decisions of the company is a reporting person.
right. So that's going to have to be interpreted at some point by case law and things like that.
Yeah, I think I had one definition. Let me read it to you. It says they serve as a senior officer reporting company. Senior officer means the president, the chief financial officer, the general counsel, the chief executive officer, the chief operating officer, or any other officer, regardless of title, performing similar functions to them. Has authority over the appointment or removal of any senior officer or majority of the board of directors or similar body. Directs, determines, or has substantial influence over important decisions made by the reporting company, or has any other form of substantial control over the reporting company. So it's an omnibus. That's in the act. It's just remember what they're after. You got to remember what they're after. If you can move money around, if you can direct, well, let's take this money that came in and buy a piece of real estate. That's who are you? We want to know who you are. It's not public now.
Yeah.
It's for the legal registry of documentation.
While we're on that side of it, in the trust, the beneficiary is also required to be identified.
Yes. So what happens is, again, when we say a trust, there are asset protection trusts, there are irrevocable trusts, there are intergenerational trusts, dynasty trusts, living revocable trusts, goes on and on and on.
Right? They're often defined at state level to trust.
Yeah. Well, no, not really. They're some of the state level they're defined, and some not so much federal, but the state law defines some of the roles that are involved. It's mostly common law, not so much state law in trusts. And so beneficiaries are really interesting. A beneficiary may not have any control, but the trust owns the controlling interest. So if it's a singular beneficiary in the trust that also is a trustee or has control, so I could form a trust for the benefit. That's what we call a beneficiary defective trust. So the beneficiary is the one that has all the control. Then that beneficiary would be a reporting beneficiary. If I form another trust where a trustee has all the control on behalf of the beneficiary and the beneficiary doesn't have control, not so much. But we need to know who the owners are. So usually it would be at the trust level that owns 25% or greater, but who are the trustees that can move assets around, and who can remove and replace trustees, which is usually the settler or the protector. So it just becomes a labyrinth of crap, so to speak, of trying to comply. So the burden that's on small business, our constituency, Arjun, is horrible. It's guesstimated that the average cost of compliance is between 4 to 10 hours of time and a cost of close to $8,000 of compliance. So, for example, in our firm, just as an exemplar, we are only charging $595 per old entity to analyze the BOI stuff, and then $250 to, if they want us to file it with FinCEN. Otherwise, they could sit and do it themselves. They could sit and file, 2-3 hours. For new entities, we've kind of only increased our pricing for formation of entities by $300 or so, $390 or so, to bring the new entities in compliance. So it's the cost of everything in the entity world, in the asset protection world, the estate planning world, got more expensive as a result of this. Not that we wanted it to be, just more work that has to be done. Which also leads us to another problem, which is really falls into a lot of your constituency in Silicon Valley. But a lot of information that's moving around that's sensitive. It needs to be encrypted. It needs to be protected information. That needs to be held in vaults. So you have the concern at the federal level as to whether or not how they're going to protect all of that data from becoming public. They have very significant penalties for breach there and jail time. For those that are communicating all of that information, for example, to a law firm, the law firm to FinCEN, all that information, there are a lot of bad characters that are going to try to intercept that information to make sure that it's encrypted and done properly. So there are the aspects of it, the tentacles of the Corporate Transparency Act, are the direct impact of things we need to do, and then the ancillary things that have to be looked at in bringing this into compliance. But we all need to understand it's 90 some odd days old. When it was passed in 21, wasn't adopted in 21, wasn't adopted in 22, wasn't adopted in 23, it was delayed. And the blast off happened in 2024. So it's here to stay. It's new. It's a moving target. We have the lawsuit out there about constitutionality. We have the law changing time limits running through Congress at this point. For sure, it will morph. So the questions we get an awful lot of is, should we wait to comply? And my answer pretty much is no. If you have a complying company or that has to comply, I think we need to comply. I really don't think this is going to be declared unconstitutional. But if we push it off, I have 12 entities I have to deal with. You'll never get it done by the end of the year. There's too many dangling participles that need to be analyzed in making the appropriate compliance with the CTA. So a lot of people saying, well, I'll wait, see what happens, see what changes. Okay, but my best opinion is that as soon as you're ready to comply, the sooner the better. One good thing, if there is a good thing, two things come about that you could talk about in your Vistage meetings. One is that it's a one-time filing, not an annual filing. Only thing we have to file is changes. So if your driver's license changes or your home address changes, it's your obligation under your FinCEN number to just update what's going on to get it done. The other thing too that's kind of good is one of the things that you'll see, and it's a good topic for Vistage, is that the vast majority of your people, many of them, of course, are going to be exempt under the large company, 20 employees, 5 million gross sales. But many of them will all have ancillary companies. And when we look at the documentation that was done, 5 years ago, 8 years ago, 10 years ago, it's all out of whack. The cap tables are all wrong. Things have been transferred. Things have been sold. We've raised money from the outside to get it done. And when you look at all of those things, it's a great time to look at all of the entities that we have. For the entities that are sitting on the shelf, I have about 3 of them that are just sitting there that I've maintained. If you don't need them, a good time to get rid of them. It's a good time to make sure that my documentation is up to speed with current owners and the way in which it's held. And I find it's going to be challenging because our company, AHP, if we need to know that Paul put his shares in his trust. How the hell do we even know that was done? Of course, now Paul's supposed to come back. We're supposed to change the operating agreement to show the trust instead of Paul Hitchcock. All right. What if he didn't do it? We're out of compliance. What is our mechanism to look at that? So I think that there are challenges. But I think that, if we want to take, what do you do with sour lemons? You make a lemonade. I think we have some of that that's involved with the Corporate Transparency Act. One of the things that we got a lot of questions on, and we'll start taking questions in a minute, is the difference between parent-child and brother-sister entities. So if AHP has over 20 employees, we have our headquarters here in California, and we have over 5 million gross sales, and we have a subsidiary that we put together that holds our intellectual property to protect that. Then we have another subsidiary that may hold all of our equipment. Those subsidiaries, those 100% owned subsidiaries, are also exempt from reporting. But that's not the best way to do it, because if we have a liability to the mothership, then they're looking to seek the assets that are owned by the mothership. Usually we would have AHP real estate, AHP intellectual property, separate entities to segregate that from the main operating entity from an asset protection perspective. So all of those segregated entities and real estate entities do become filing entities under the CTA. One of the concerns that we have being in this specific area of the law is that does this create a chilling effect from people doing appropriate and proper estate planning and appropriate and proper asset protection plans? Like, well, I got to do all this CTA stuff now. I'm going to use less LLCs. I'm not going to create that brother-sister entity, which is appropriate and proper to do. Let's not let the tail wag the dog. None of us are thrilled about this, but the bigger picture is protecting our assets, protecting our IP, protecting our real estate, our equipment, et cetera, and making sure we avoid probate, minimize estate taxes, and all the good things that require these entities. Let's not do entities because we're concerned about CTA. All right, and with that, I think it's a great time to perhaps start getting some questions if we have any.
Yeah, I encourage everybody to put questions up there. I do want to mention that on the FinCEN site, it's interesting because that case that came out, Yellen, they've already appealed it, and they said that so it's already in Justice Department has appealed it, and it's interesting because they name a guy, Isaac Winkles, doesn't have to file. He's part of that case, and anybody who's part of the National Small Business Association. Otherwise, everybody else. So it's right up on the website. Yeah,
correct.
Arjen, I've got some questions that were sent in ahead of time. Do you have anything you want to jump on right now?
No, I think this is just as you were talking there, it was clear to me that this is going to impact many people, and that it's something that's going to, I guess, also going to have a big impact on the legal industry, because there's going to be a lot. I guess the good news is a lot of work to do, but that is how do you manage do you have the capacity to take it all on all at once? Probably not.
Yeah,
So,
well, we do. We have actually set up a whole CTA department that is providing CTA counsel. We have a service that is actually sitting there and doing the filing. So you and I don't have to sit there on a Sunday in 3 hours try to navigate their website to actually file. And we have analysts that are analyzing what needs to be filed, and we're doing that all for a flat fee. So as far as we're concerned, we would rather not have to do this. It's not fun work. It's just something that has to be done.
Right.
Harry, are there industries that are disproportionately impacted by this? I mean, I think of people who own rental income property.
Yeah.
It seems like they just are.
Yeah, sure, because none of them have 20 employees.
Right.
Most it's all, property A is an LLC A, property B is an LLC B. They don't have any employees there. Every one of them is a CTA required file, but it's one time. So now when we put them together, when we put together a new entity, Arjun, we just file it. We just turn around and do it.
Okay.
Arian,
see
there's a question there. Yeah.
Bill Cowan. Hey, Bill, how you going? Glad to see you there. He's asking, what are the pros and cons of getting a FinCEN ID?
Well, I think that the cons are it just takes a few minutes in order to do it. The pros are for every time you need to have beneficial ownership or control reported, Bill, you just put in your name and your FinCEN number, so your home address is not displayed every single time, and all of your driver's license and/or passport is not displayed just once. With FinCEN, after that, it's just a number. So every time I have to report as a company applicant, as a supervising attorney, I would have to, on every one of my clients, give them my home address, all right, and my driver's license. I don't want to give my clients my home address and driver's license. And every time we'd have to do this. So now they just put down supervising attorney Harry Barth, FinCEN number 001241241244. So there are really no cons. I think we should all have a FinCEN number because the same information is required if we go with a direct report or we use our FinCEN number. But we do have the obligation to make sure that it keeps up to speed, and the reporting company has an obligation to make sure that we are up to speed. And how the reporting company is going to know that our managing company, which is a corporation's board of directors, has turned around and kept their FinCENs up to speed, I have no idea on earth how that's going to be enforced, which is part of the we'll call it the cloud or the mystery of the CTA. In principle, and it was one of the principles that the court in Alabama, when declaring it unconstitutional, said, there are a lot of times the court said that legislation is absolute nonsense, but it is constitutional. He says, and there are some times where the legislation is noble with a good purpose. Nobody wants to see terrorist financing. Nobody wants to see money laundering and nefarious crimes being committed behind shell companies, but it could be unconstitutional the way in which they're going about doing it. So it's noble legislation. And that's why I think, because of its goal and what we have, for example, you can't do a notary. You do a notary, they want your fingerprint, they want your driver's license, they want your address. It's in a notary. So if it's good enough to be a notary to do any notarial act, then, oh my God, then I would imagine they should have that same information as needed to help prevent financial crimes. We'll see.
And would you say that there's a one-to-one correspondence between a social security number and a FinCEN ID?
No, there's nothing whatsoever. Social security number is one thing. New FinCEN ID is a newly issued government number. There's no correspondence between the two whatsoever.
So they don't ask you to put in your social security number when you register the FinCEN?
No, the only time that you'll get involved in a social security number, which they already know, by the way, is when you are filing a single member LLC that's tax disregarded, that has not gotten an EIN number for convenience. Because you can get an EIN number for convenience and you're using your social security number, that entity must have that unique number, which does become your social security number.
So then you're saying that like a FinCEN ID is kind of related to an EIN?
Yeah, it's just a separate number. EIN is the number for our entity.
Yeah.
The FinCEN number is the number for Arjun.
For the person, yeah.
Yes.
Okay.
Yes. You could have an LLC, for example, that has 10 owners at 10% each. Not one of them is a beneficial owner. Not one of them owns 25%. But somebody's going to have control. You could have a 1% owner that's the managing owner of an LLC. The 99 don't have to report. The one has to report on behalf of the company, but it is a reporting company.
All right. Okay. Thanks for that.
All right. Any other questions that we have, Paul?
I think we're good for now. Any other questions out there before we end it? Looks like we're good. We did record this, so we're going to send out the recording to everybody that signed up and attended for sure. So look for that. That'll go out in an email in the next few days or so. Yeah. And Arjen, thanks for being here. Harry, great as always. Thanks everybody. Really appreciate it.
Okay,
all right.
thanks.
And the old story, remember the Greeks. You may not like the message. Don't kill the messenger. All right, guys. Well, thank you very, very much. Take care.
Thanks for coming.
Okay. All right.
Bye-bye.
Take care.